As with confidentiality, you will need to determine what pieces of intellectual property will be covered by your code of conduct, as well as your policies and procedures. Intellectual property typically consists of items such as copyrights, patents, industrial design rights, some trade secrets, and the designs and marks, i.e. trademarks, representing your brand. These are essentially an indication of ownership as recognized by the Patent Office. Intellectual property also includes works in progress that may later achieve ownership status. These are the most sensitive as they do not have the full force of copyright law behind them. Exposing work in progress may lead to a competitor achieving the status ahead of you. In a similar manner, you may have access to intellectual property belonging to clients or business partners. There are likely limitations as to how you may use the intellectual property. Improper use may lead to infringement, which is a legal violation. An important aspect of intellectual property is ownership. Some companies ask employees to sign agreements to assign ownership to the company. Others may allow the employees to retain ownership. Still others may require ongoing protection, even after leaving the company. For example, the Oracle Code of Ethics and Business Conduct includes maintaining the confidentiality of Oracle's trade secrets and proprietary information is an important element of such protection. This obligation continues even after you leave the employ of Oracle. Intellectual property has many more legal concerns than simple confidential information, so you may want to consult with legal counsel before making a decision on what to include in the Code of Conduct and what gets put into policies and procedures. It is very important to be very clear with readers of the Code as to what a violation actually is when breaking the intellectual property code. In particular, some violations may result in loss of exclusive ownership of intellectual property, so you will need to be careful. Let me give you a quick example. At one company I worked for, an employee printed out the entire and extensive client database, often considered a trade secret or, at a minimum, confidential information. The employee was caught when they tried to sell the data to another company. The employee was sued, and at the trial, the judge decided that the company had not taken sufficient measures to protect the data, and therefore the client database information was considered to be public domain, and the company lost the case. So you can see by this example that by not creating a clear code as to what the company confidential information is, they may lose rights to very important information.